Hi, I'm Konstantin Gerber, PhD in Law, Pontifical Catholic University of São Paulo, Fundamental Rights Research Group, Professor of Constitutional Law at the Postgraduate Lato Sensu COGEAI, Human Rights Consultant Lawyer. So what about free, prior, and informed consent of indigenous people? So let's start with the International Labour Organization 169 Convention, which says in Article 6, governments shall consult the peoples concerned through appropriate procedures and in particular through their representative institutions, whenever consideration is being given to legislative or administrative measures which may affect them directly. Establish means by which these peoples can freely participate, to at least the same extent as other sectors of the population, at all levels of decision-making, in effective institutions and administrative and other bodies responsible for policies and programs which concern them. And establish means for the full development of these peoples' own institutions and initiatives, and in appropriate cases provide the resources necessary for this purpose. The consultations carried out in application of this convention shall be undertaken in good faith and in a form appropriate to the circumstances with the objective of achieving agreement or consent to the proposed measures. So, let's begin. This article has been construed and interpreted by the Inter-American Court of Human Rights. So, I will refer two cases. The first one is the Quichua indigenous versus Ecuador, people of Sarayaco versus Ecuador. So these are very important standards of the Inter-American Court. And another one is the Saramacca people versus Suriname case, also very important. So the court said that the consultations with indigenous peoples must be undertaken using culturally appropriate procedures. In other words, in keeping with their own traditions. So this is the paragraph 201, which says to respect the indigenous people's customs. So another interesting paragraph worth to mention is also the paragraph 187, which says that it should be emphasized that the obligation to consult is the responsibility of the state. Therefore, the planning and executing of the consultation process is not an obligation that can be avoided by delegating it to a private company or to third parties, much less delegating it to the very company that's interested in exploiting the resources in the territory of the community that must be consulted. So this is happening right now in Brazil. So the company cannot do the process, right? The company can file a petition in some organ in the state in order to have the consultation process started, but this is what cannot happen, right? Because this is the risk of bribery, right? So the Inter-American Court is very emphatic about that. So let's see then the paragraph 186, which says that well, the consultation must not only serve as a mere formality, but rather must be conceived as a true instrument for participation. So this is also important to highlight. Consultation in good faith is incompatible with practices such as attempts to undermine the social cohesion of the affected communities, either by bribing community leaders or by establishing parallel leaders, or by negotiating with individual members of the community, all of which are contrary to international standards. So, the negotiations must be undertaken with the representative entities, so the legitimate entities, right? This is also important to stress. So 180 paragraph. So regarding the moment, so consultation must be carried out in advance. So the court has observed that the consultation should take place in accordance with the inherent traditions of the indigenous people during the first stages of the development or investment plan, and not only when it's necessary to obtain the community's approval, if appropriate, because prior notice allows sufficient time for an internal discussion within the community to provide an appropriate answer to the state. So these are important paragraphs from the Quechua indigenous people of Sarayaku versus Ecuador. So now let's check some important paragraphs of the Saramacca people versus Suriname case. So we have two important paragraphs. The first one is the one which refers to the UN Special Rapporteur on the situation of human rights and fundamental freedoms of indigenous people. And this guy observed that free, prior, and informed consent is essential for the protection of human rights of indigenous people in relation to major development projects. So, great projects or large-scale projects which may affect the indigenous communities must undergo through this procedure, right? And so this is also an important standard, because what happens, there are many projects which require prior consultation. Hydroelectric plants and protected areas, mining, waterways, railroads, highways. So all these are examples from Brazil. So in the case of the hydroelectric plants, there is this famous case of Belo Monte, which was subject of a precautionary measure in the Inter-American Commission of Human Rights. But then the Inter-American Commission suspended this measure, but it was related to this issue of the prior consent. The precautionary measures are usually edited for these situations of threat to life, right? But and so people, but in this case, when you have a threat to the survival of a people, right, to its integrity, cultural identity, it can also be understood as something really urgent, right? So in Brazil, we have a constitution. Well, like some other countries like Paraguay, Peru, Colombia, or even Mexico, we have these provisions for indigenous people in the constitution. This is really interesting. Brazil has a constitution and with indigenous rights. It was one of the first to set that in the constitution. But the problem is to how to implement that, especially in regards to the land, indigenous lands, right? All the procedures are simply abandoned, right? So no interest at all in concluding the procedures to give the recognition of the indigenous lands, territories. Well, but what about the Brazilian Constitution? So we have special provisions on waterways and on mining, right? So these special provisions, they mention the need for a hearing, not necessary a prior consent consultation. It's different, right? But we have to read the Brazilian Constitution jointly together alongside with the international law of human rights. So with the lens of the international law. So in this case, we can also apply this convention because Brazilian Constitution has provisions which open itself to international law. So we have this communication between national law and international law. And so it's really important to stress that because many governments make this confusion, mix some concepts, because one thing is the public hearing from the environmental law. So this is only a non-binding hearing, right? It's a non-binding hearing, and it's different from a procedure which must be deliberative. So one thing is the consultants that is deliberative procedure. It's different from the environmental laws, which only foresee public hearings, which are non-binding. So this is really important to highlight, because many countries like Brazil, like Chile, and others, and may try to justify that they're implementing these international provisions through their environmental laws. So it's different. Well, let's. What can I say about Peru and Paraguay and Mexico. Peru has a decree from the 8th of 2011, a statute and also a decree, and it has an experience in building it through its bureaucracy, through the state bureaucracy. So the Ministry of Culture has the duty to offer trainings and capacitation and so on. Well, to help the organs which are responsible for the projects. So the Ministry of Culture has this duty to offer guidelines and so on, offer trainings for these procedures to happen. And so there is one author that must be mentioned. He is Gustavo Zambrano Chavez. He wrote a chapter in a book recently edited by the Externado University of Colombia. And so in his chapter, he shows that there's also these monitoring activities. This is really important, to have monitoring commissions or monitoring work groups to follow up the agreements. There is one project now, a bill. There's a bill being debated in the Congress of Mexico, which also foresees that. So, pursuant to this bill, there's also there's a need of these monitoring committees, right? And this is really interesting to highlight. And here in Peru, the indigenous people have the right to file a petition in order to participate in any process of consultation which may affect them, right? So this is interesting also how the states regulate this petition procedure, either for the enterprise, for the companies, like in Paraguay. In Paraguay, the companies may file a petition to this indigenous institute, this Instituto Paraguayo del Indígena, so this indigenous rights organ of Paraguay. So the companies can file a petition in order to start a public consultation, right? And here in Peru, the indigenous have a petition right to participate in the process. So, well, what about Peru? Well, Peru has a story of many conflicts in the past, but finally this statute was enacted, and it's really interesting how the bureaucracy starts to implement this right. I think this is a dilemma for many indigenous people, because some avoid to participate, refuse to participate, because they understand that these procedures violate the international standards, but some participate. So it's this is in Colombia, this is in Peru, or even in Mexico. But well, it's a right that has been being implemented, being enforced in different ways depending on the country. So Paraguay has a decree also from 2018, and Peru has also a statute and a decree of 2011. And Colombia has no specific decree or procedure. Many of the cases of Colombia were all recognized by the court. So it's a case law construction, right? But Colombia is worth to mention that is the place where the most cases of the highest number of consultations in the Americas, for sure, is Colombia. Only in 2020 there were ongoing more than 10,000 procedures. So this is really expressive, a number of Colombia. But well, so what about Colombia? So let me comment here, and then there is this interesting book edited by the Rosa Luxemburg Foundation. So the author for Paraguay is Carmen Alice Cohen Mercado. The author for Colombia is Guillermo Padilla. And the author for Mexico is Magdalena Gomez. So it's this data here is from Guillermo Padilla, right? And well, Colombia has also, the Constitutional Court has also developed this concept, and in some cases it said that indigenous people would have a right to say no, a right to veto, right? So either Colombia and Brazil have this experience of autonomous community protocols, right? Like a self-enforcement of the international standards. And in these community protocols, they may say that some subjects are not negotiable. So some issues cannot be subject to this prior consent, because they are like in the if there is any impact in some regions, some sacred places, this would be a deadly threat to their vital existence and to their integrity and to their cultural life. So there is this right to say no. We can also say, imagine that there's these environmental impact evaluation, but sometimes there's also need of this spiritual impact evaluation, right? because you cannot simply bomb a sacred place, because this may represent an attack to its integrity of the people. So well, but there's one case from Colombia, actually from 2018, on the matter of on the glyphosate program, right, for the crop eradication programs. So in this case, the court says that the indigenous people don't have the right to say no, but the state also cannot force any agreement. So there must be a balance between state and indigenous people. In this case, regarding the glyphosate, the restart of the glyphosate program for crop eradication, the coca crop eradication in Colombia, right? I'm reading here the petition filed by the organization De Justicia, right? So there are many cases on this issue. Well, and what about Brazil? Brazil, the judiciary also recognizes this right, this fundamental right, but notwithstanding, what happens? Here, there is this procedural remedy in favor of the state, which I would translate by suspension of the injunction. It's a procedural remedy in favor of the state, which simply knows any attempt to access to justice. So here in Portuguese we call it suspensão de segurança or suspensão de liminar. So this suspension of injunction was also subject of a petition filed by an organization called Instituto Socioambiental, which alleged that these procedural remedy in favor of the state violates access to justice, right? So this is a petition filed in the Inter-American Commission of Human Rights. Let's see what would happen. So Mexico, well, Mexico, I'm reading here a alert from a law office, the Holland Knight alert, an article of Alejandro Landatierre, Carlos Ochoa, and Aldo González. Consulta, México aprueba proyecto de ley de consulta de comunidades indígenas y afromexicanas. So, they're still debating this bill in Mexico, but there will be two kinds of consultation. One consultation which has the objective to obtain the consent in specific measures, and consultations which don't require the consent. So this might be an idea of I don't know, national interest or something like that, because they just simply put aside some measures which don't require the consent. This is an important distinction because we say consultation, but the convention says that the objective of achieving agreement or consent. So the consent is needed in most of the cases, right? So the Inter-American Court interprets that as a need of consent, right? So this is something different that I should highlight here in Mexico. Well, then the consultations, projects which impact lands, natural resources of indigenous communities and Afro-Mexican communities, and mining, water, and also the genetic heritage. So this is also interesting issue, because now there are ongoing some petitions for the patent of psilocybin in Mexico. So what about the genetic heritage of the Mazatec people, right? So this is interesting also to mention. Well, and then there is these they set up some also these following this monitoring commission. Some specific organs here, some technical assistance organs, and this is also important to highlight the need of a specialized bureaucracy, right, and appropriations bill also to foresee a specific appropriations for this policy, this public policy, right? So, and this is about Mexico. And what about mining? So, there are some standards also in the United Nations Declaration of Indigenous Peoples. So some standards are written in the UN Declaration. So states shall take effective measures to ensure that no storage or disposal of hazardous materials shall take place in the lands or territories of indigenous peoples without their free, prior, and informed consent. So some countries just repeat that in their statutes or in their decrees, right? And there's also an important provision of the ILO Convention,